Hello and welcome. You are listening to an informed take on current events brought to you by law students and staff of Queen's University Belfast. This is LawPod.
Good afternoon. We are starting a LawPod discussion today. I would like to start by introducing myself. I am Teresa Moreira. I am the head of the Competition and Consumer Policies branch of UNCTAD, which is the United Nations Conference on Trade and Development based in Geneva. And I am here today as a guest host because UNCTAD in 2010 launched a research partnership platform, which is just an informal framework where we gather universities, scholars, competition and consumer protection experts, and representatives of different stakeholders to discuss key issues that the research centers and the academics are working on and that correspond to the priorities of UNCTAD's work, which is devoted to assisting developing countries in using competition law and policy, in this case, to better integrate the world's economy. So today we are here because of the recently launched report entitled Developing Countries' Experience with Extraterritoriality in Competition Law. And we will have not only the author of the report, Dr. Marek Martyniszyn from Queen's University Belfast School of Law, but a number of scholars that will comment on their views and share with us insights regarding this topic. So I would like to start introducing our guest commentators. Starting with Professor Qianlan Wu from the Faculty of Social Sciences, University of Nottingham, Professor Imelda Maher, Sutherland Full Professor of European Law, Sutherland School of Law, University College of Dublin, Professor Alexey Ivanov, Director of the BRICS Competition Law and Policy Center at the Skolkovo Higher School of Economics in Moscow, Russia. And finally, the author of the report, as I mentioned, Dr. Marek Martyniszyn from Queen's University Belfast School of Law. So I would like to start with Marek's report, of course, asking to share with us some key issues regarding this very interesting study. Can you please tell us, Marek, what do you mean by extraterritoriality? And how do you think we should talk about this in the broader context of competition law?
Thank you so much, Teresa. This is a terrific question, and indeed, I'm grateful to the opportunity to conduct this project within the RPP framework. So many thanks to you and your colleagues for making this possible. Without it, it would not be possible. But what is extraterritoriality? By extraterritoriality, we simply mean application of local law to parties whose often purely foreign conduct harms consumers and businesses locally in the jurisdiction applying the law. And what's the significance? Why to think about it in competition law? It's simply because many of the listeners would think that with the progressing globalization and quite a lot of international commerce, there is a global fix. However, in competition law, no multilateral collaborative way of dealing with illegal anti-competitive conduct has been developed. So quite often, competition agencies all over the world are left at the mercy of, for example, international price fixers, and they have to apply domestic competition law to reach them beyond the limits of their country, so to apply law extraterritorially. And that's what the project really focused on.
That is very interesting, of course, from the point of view of UNCTAD, since we are so much focusing on international cooperation. I think this is really a timely topic, as you mentioned. Can you now share a little bit with us the study in itself, how it unfolded, and what are the key findings?
Right. Thank you so much. So yes, this study is quite interesting because it's first such empirical study of its kind, actually checking what is the situation in the developing world in this space, because we focus on developing countries. It relies on input from 40 countries and economies in transition, so it's quite robust in scope. And it focuses on very diverse group of countries, so from large BRICS, so Brazil, Russia, India, China, South Africa, so very important developing countries, to much smaller and less affluent states. Moreover, um, many of the states have different level of expertise when it comes to competition law. Some introduced competition law in 1990s, and some introduced competition law only recently. So that's quite interesting because it really gives us an idea of where we are. Now, what is quite interesting is that actually there's more going on than one would expect. So it's quite promising. The situation is better than many would think. 34 states out of the 40 that took part in this study recognize extraterritoriality as such. 33 countries provide explicit provisions enabling domestic competition agencies to apply law extraterritoriality, and Chile allows for it thanks to judicial interpretation of existing law. There is, of course, some diversity of tests, and there is a diversity of experience. So there's quite a lot going on, more than many would think on the surface.
Thank you. I think that this is also very interesting. I think I will now like to ask questions to our other guest speakers or commentators before I give you then the final word. And for that, I would like to ask Qianlan, if I may, what can she tell us about concrete challenges faced by developing countries, namely China, regarding this particular issue and any other bilateral or regional cooperation issues. Well, thinking of the Asian context. Qianlan?
Thank you, Teresa. Yes. Well, based on the experience of China's extraterritorial application of its competition law regime, it kind of the statutory law, anti-monopoly law adopted in 2007, provides explicitly the extraterritorial application of the law based on the effects doctrine, provided a business conduct is proven to have caused negative effect on the economy of China that triggers the application of the anti-monopoly law. So this has been kind of in application ever since 2008, when the anti-monopoly law took effect. So I think from the in the global sphere, I think the effects doctrine is somehow generated by the courts in the mature competition regimes has somehow provided quite useful reference for the China's competition regime to refer to when it develops its own its own extraterritorial application of competition rules. It also justifies the statutory provision of the anti-monopoly law. With respect to the enforcement, in the public enforcement, the main challenge faced, the competition authorities have completed a few investigations by calculating the harm caused by the business conduct to the Chinese economy, but with reference to the Chinese legislations. So the main challenges faced by these competition authorities would be in terms of collecting evidence, asking who is going to be the whistleblower, and also kind of advocating China's international cartel legal regime, asking for cooperation. Sometimes the business parties are not necessarily motivated to cooperate with the Chinese competition authorities. In terms of private enforcement, so far there hasn't been any litigations brought by private parties in front of the Chinese courts, although it is legally possible. Again, the Chinese judiciary, the courts face the application, again, face the same challenge in terms of collecting evidence and also enforcement in the future, the enforcement of Chinese court decisions outside the Chinese jurisdiction. So just to sum up, I think the extraterritorial application of competition law based on the effects doctrine has provided more teeth to China's competition law regime. It makes it more powerful to catch certain harmful business conduct in the global sphere, but it also makes it possible to set out the scene for China to seek and develop bilateral collaboration with global trade powers such as the US and the EU. So what we can observe is that the US, China and EU, China bilateral cooperation in terms of international antitrust has somehow shown certain convergence with the US, EU bilateral collaboration, because the US, EU and EU, US, China and EU, China bilateral cooperation both contains the basic elements of bilateral cooperation, including the exchange of information, basic elements of certain COVID application of committee, and the consultation as a main means to resolve disagreement among the parties. Going forward, I think the main challenges that China faces as a developing country in kind of strengthen its bilateral cooperation could, for example, include how to make it more effective in terms of exchange of information among competition authorities, the application of committee and its compatibility with Chinese domestic law, and the effective resolution of disagreement among the competition regimes. So that's what I have just seen in terms of challenges. Thank you.
Thank you very much. I would like now to turn to Imelda and ask her, among other things, how does, on the basis of your experience, how do you see the reliance on decisions and judgments from other jurisdictions, which is a point that actually Marek addressed, and of course, I think is one of the very interesting ways forward, even though not an easy one. So how do you see this unfolding? Are there any requirements? I would like to hear you on that. And also, if you could share with us some views on, let's say, an assessment of the positive committee experiences, because as you have seen, well, bilateral cooperation, regional cooperation, international cooperation do exist. And several jurisdictions are engaged in, let's say, these three avenues. And yet, UNCTAD research constantly underlines that there is still not enough enforcement cooperation and lack of trust, and not only, let's say, legal type of obstacles, as Qianlan was mentioning, but lack of trust or lack of resources or lack of familiarity with this issue. And so I think that at international level, we do need to think a little bit on more innovative ways of better promoting international cooperation. Over to you, Imelda.
Thank you, Teresa. A brief comment first on what we would call, if you pardon the term, piggyback actions, where I think one of the exciting innovations, and Brazil, as Marek's research has shown, is really in the vanguard of this, of taking actions against very large transnational cartels, taking the evidence essentially and applying it within the domestic context. Like that's a real cost-saving exercise. It shows good collaboration between high-level, experienced, well-resourced competition agencies and others. And Brazil, of course, would be, as one of the BRICS countries, would be in a better position to do that than many others, but also is now developing expertise in that regard. But we still know from the report and from their responses to that that Marek put out in his survey, is that they still have cases on their books from 2010. They're waiting because of practical challenges, which, as you are suggesting, are the sort of thing that we should be tackling. And there's a lot wrapped up in the question, right? So that's the piggyback, if you like, phase one. The second thing, this question of positive polity. like we find that, I suppose, the most sophisticated articulation of that is the agreement between the Americans and the Europeans. But we know from the first iteration, it had almost no effect. It was a very mild way of cooperating. But I think we can learn from that, because that shows us that even where you are well established, even where you're powerful, put it bluntly, both internationally, but also vis-a-vis multinational firms, there is still an inherent caution in the way agencies approach each other, especially when they're moving across borders, which suggests that starting cautiously doesn't mean things can't get better. You have to start somewhere. So even if the comity is limited to start with, that doesn't mean it shouldn't happen. You're not going to go straight into a very sophisticated agreement. So small steps help. Now, why do small steps help? Which brings us to the next point, which is the challenges around enforcement, a lot of which are procedural, some of which can be addressed domestically, again, as the report shows, that you can change rules, for example, on service of notice of proceedings, and resort to publication where delivery is proving impossible. And that can be addressed through domestic legislation, as the report discusses. However, if we want to further augment cooperation around information, helping, supporting each other in terms of securing evidence in particular, and perhaps even in relation to enforcement around fines, which would be very interesting. I think then I want to step back a bit, and I think this is where UNCTAD actually plays a really important role and has played a role to great effect over the years, which is the development of trust. Again, if someone comes cold calling, it doesn't work. What's needed is to develop these relationships that often are almost at the individual level between case officers, through, of course, through the institutions onto a more sophisticated level. And this is done through, I think this is done partly through having robust legal frameworks in place. And I think, again, the report shows us that increasingly that is the case. This conversation would, in short, would have looked very different 20 years ago. And we can talk about it very differently. And we should acknowledge that things have really moved on. And that's a very good thing to be able to say. So you need a robust legal framework. But then we run into questions, as you've highlighted, around resources. I often wonder, when you teach students in LLMs and you're teaching them competition law and they're going back and they're interested in working in agencies, I often wonder how long they'll be in the agencies before they're snapped up by private practice. Now, I don't know how you would, as a public servant, I don't know how you address that issue. But that is that leakage. If you could make it a revolving door, that would be great. That if we could have more where it would become a career enhancement to go work in an agency, as is the case actually, certainly in Europe. I wouldn't be so familiar with some other jurisdictions. It is a very positive thing to be seen to be moving in and out of the agency, and maybe try and construct that in a way that's more of a virtue. And very practical resources around computing technology, especially in those developing economies, would be important to make sure that agencies have enough resources. And finally, the question of networks. Networks are very good at building trust, and that operates, I think, on a number of levels through information sharing. And this can be soft information or grey information, as it would be known, which is information to which agencies are privy, but it is not secret. The problem for the agencies, and I think, again, we mustn't lose sight of this, is that secrecy is very important for a competition agency. They have to be able to show that the information the confidential information that they garner from companies or from whoever their subjects are is robust, that they can protect that information as appropriate. Now, that doesn't mean you can't share it with another agency, but you must do so within parameters of protocols that are robust and that are very well protected. And to enable to do that, you need to show trust. You do this, I think, through building relationships, through collaborative arrangements. I think, ironically, given COVID times, meeting people is actually very important. I think the shift towards greater technology is very helpful, but will only take us so far. And I think, again, once times change, it'll be very important for people to meet less frequently, but in greater depth, because a lot of the clearing work you need to do before you get into a room with someone can happen now in this kind of environment, either through audio or indeed with visuals to help as well. So I think UNCTAD has helped with networks. We have many competition networks. They've been around since the 1950s. The most recent is one emerging in Africa, where they've only had 2 meetings. It's led by the South Africans. But there's plenty of models that we can draw on and continue to build on. The thing is, they seem to wax and wane. Sometimes they're very active, sometimes they're not. But I think that activity should be driven by the projects, and in particular, if there's particular cases that agencies want to work on collaboratively. So I think networks help, but they're only one aspect of the answer that you're looking for. Thanks.
No, thank you very much, and thank you for mentioning UNCTAD. I do think that the work of international organizations and regional organizations and networks has really, as you just said, clearly changed the overall picture. I don't think 25 or 30 years ago one could have imagined so many developing countries, for instance, having adopted competition law and setting up institutions, and in some cases being very keen on effective enforcement, but of course, still a number of challenges remain. So now I would like to turn to Alexey and ask, on the basis of the very substantive and extensive research that the BRICS Competition Law and Policy Center has been conducting, how do you see this regarding the BRICS, which are, as other speakers mentioned, in a way, in a privileged situation? So Imelda mentioned, Qianlan mentioned China, which of course it's a huge country, even though they are probably one of the last of the BRICS to have actually adopted competition law and policy. I think Brazil is a extremely successful experience. I in the past, when I was with the competition authority, I followed up, let's say, their growing assertiveness and effectiveness. So I think that is very, very relevant. But again, these are very big jurisdictions. Of course, Alexey is very close. Well, he's based in Moscow, but he's working with all of these countries. So Alexey, over to you on your views on all of these BRICS jurisdictions or others.
Well, thank you, Teresa. Thank you for having me, and thank you, Marek, for this interesting and very kind of thoughtful work you did for UNCTAD and in developing jurisdictions in general. And I want to cover a little bit Russian experience, maybe in more particular, and then answer the question you posed, Teresa, on BRICS. I think those are kind of interrelated things, because Russia is because it's a little bit like, for Russia, a matryoshka doll, story, because we have our own jurisdictions, and we have Eurasian Union covering our jurisdiction with other neighboring countries, and then further on we have some sort of quasi-regional cooperation with BRICS. Why I call it quasi? Because it's not actually a region, it's more like community or a club of countries, and of very particular nature, actually. I think a BRICS cooperation, a BRICS alliance, it's quite a little bit unique in the sense of international governance, framework. If we try to classify different forms of organizations, we definitely have, international organizations like UN, which UNCTAD is part of, WTO, and so on. We have regional unions which normally starts with customs union of one type of or another, and then we have this type of international in essence, because BRICS is international community combining very different jurisdictions with very different economic and social parameters, but also trying to kind of build a closer network to define the way the world is developing. So it's a type of building a community within international community. So and the reasons why BRICS emerged actually in the first place, it's a very interesting question of its own, but it's probably deserves a special podcast conversation. But I will start with this positioning of Russia within this matryoshka doll system, and extraterritoriality plays a very interesting particular role in this, because we already have a lot of discussions within community of Eurasian countries, of Eurasian Union members, what is actually as a mandate for Eurasian community or Eurasian Commission in this particular sense, because they have a mandate coming from transnational behavior of subjects, of companies, and transnational relations as it's framed by the union. And this also brings the topic of extraterritoriality to the Russian authority, because in many instances there is a discussion whether this topic, this matter, should be covered by Russian authority or brought to the Eurasian Authority. And I know this type of discussion also exists in Europe, but I think criteria on which European Commission takes cases and criteria and mechanisms on kind of dispute resolution between national authorities and European Commission are more established and I would say a bit more transparent than what we have. And one of the reasons, because I think criteria for European Commission, mandate are more like, discretional in a sense, and allowing European Commission to step in number of cases, not always proving that those cases having this kind of, extraterritorial nature. But for Eurasian Commission, the criteria of transnational or extraterritorial for single jurisdiction characteristics of a violation or economic relations taking place in the context of investigation is mandatory. So they have to prove that something happening and having extraterritorial for either Russia or Kazakhstan or Belarus, nature. And that's already opening up, sort of Pandora box for discussions. What is extraterritorial? Because it's very unclear, especially in such interrelated economic, affairs like we have within Eurasian Union. And then further on, we have some global, events or global matters, which definitely touching, both Russia and other Eurasian countries. And here, I think BRICS community is coming in of very, being very instrumental to helping to do what I would call, leveling the negotiation power or leveling kind of the playing field between BRICS authorities, smaller authorities, because Russia is not like a big authority. It's a maybe large authority institutionally, but it's not covering a huge economy, because Russia is relatively small economy considering, global share in GDP. It's a bit more than 2%. So China is a different story, but also, even standalone China can't actually negotiate equally with number of global players, and we saw it in the past. And but being united, we increasing massively negotiating power, and that actually plays a role, very significant role, I think, in cases like merger review cases of some global mergers, and the case of Bayer-Monsanto merger, which was recently decided, not already recently, like a couple of 3 years ago already, but still relatively recent case, were decided on the basis of kind of collective bargaining on the side of BRICS jurisdictions. And that actually has shown its efficiency. Sometimes, and the question of extraterritoriality in this sense is very interesting, and because in some cases you have to prove a real like nexus relation to your territory, but sometimes you can't predict this with enough evidence, and you can't expect in the changing world, in a world which dynamic and constantly changing, and sort of markets are very blurred in their boundaries, and they always changing. And in this sense, you can't really prove sometimes with sufficient evidence that certain merger would have impact on your markets or your economy. But being involved in the discussions of the global community of competition authorities on the terms on which this merger would be cleared includes you in a kind of decision-making process on a global scale, which is extremely important for any developing jurisdiction. So in a sense, let's take this Bayer-Monsanto merger, for instance. Sales of Bayer and Monsanto together in Russia were relatively small in terms of, proportion, in terms of their global sales, so it was less than 2%, I think, of their global sales. But importance of technology involved in the discussion of this merger, because those technology were related to next wave transformation of agricultural industry, were so important, then being included in the process of decision making for Russian authority was imperative. You couldn't be put outside of the discussion how innovation process, how technological development would be organized structurally, or in terms of ways in which innovation takes place, development which passes innovation takes in this industry, it couldn't be excluded. And the way to be included, it's not trying to impose your jurisdiction unilaterally, but trying to join the group which has enough negotiation power or leverage to solve this, matter, or to clear this merger on equal basis with the global corporation. See what I mean? Like that's what it gives to authorities like Russia or South Africa, for instance, which is relatively small economy comparing to the strengths of these global companies. So I would say extraterritoriality is a bit old school concept. We shouldn't think too much in nexus categories, whether it has implications on your economy right now, right here. It should be more considered in a way that global economy operates as a single enterprise in many instances. And some markers you can't really say whether they like local, national, regional, whatever. They all global in their sense. Whether they would have implications for your economy tomorrow or the day after tomorrow, you can't prove in many instances. But you have to be included in the discussion on the trajectory of development. And that's what actually should be achieved, because we are lacking, as you perfectly know, we are lacking international legal regime for competition protection, on global scale. So not having this, authorities of this, mid-level type, like Russian authority, which is positioned not within like a bunch of small developing jurisdictions, but not also in the premium league. So we are not playing in the first league. We're not playing in like third league. It's like a second level, whatever, second tier authorities. So but it's very important to be included. So international cooperation gives us and other authorities like us this opportunity, this ability. And so I think it's a next big thing for international cooperation within smaller jurisdiction, or not like premium, first tier jurisdictions, to get together to increase our negotiation power, and then try to be included rather than excluded from the process of decision making about the architecture of the global economy, because that's what actually at stake. Sorry, we are discussing the next, architecture or the vision of the global economy. Yeah, that's my kind of take on the report and on this topic.
Thank you very much. Also, very interesting remarks. Well, from UNCTAD's point of view, let me say that we are great believers in the power of what I would call regional cooperation, but especially, of course, considering developing countries, young and small competition authorities, because as you know, there is a sort of proliferation of regional economic organizations that actually have adopted either competition provisions or committed to cooperate at regional level in this field. And we see that in a way, as Alexey was suggesting, as a means also to increase their leverage vis-a-vis big global companies. Well, global companies as a whole, even though this is easier said than probably done. I would like to still hear from Marek on the recommendations of your report, asking you what, on the basis of the research that you conducted, what do you think could be the recommendations and the policy options to explore at international level, of course by UNCTAD, but by other international organizations or networks, since we do live in this global and digitalized economy, and unfortunately with going through a pandemic that is lasting longer than I'm sure all of us could ever have thought, not even wished for. So what would come to you as maybe more easily implementable recommendations from the set of your suggestions? Over to you.
Thank you so much, Teresa. So I'm very pragmatic in approach, and that was the way the report has been framed. There is a number of pragmatic steps that can be taken to actually narrow the enforcement gaps. And colleagues here on the panel touch upon many of these ideas already, and that's really valuable. There is also a sister project, an article in the Journal of Competition Law and Economics, which touches upon this issue, and I will sort of speak to all of those. You talked about UNCTAD and the role of UNCTAD, and I think one of the steps which still can be taken and would be very valuable would be to provide a textual basis for extraterritoriality in model law on competition. So UNCTAD's model law on competition, many listeners would know, is a leading international benchmark for many jurisdictions. If you want to think about your competition legislation, you would often refer to UNCTAD model law on competition. And covering extraterritoriality there, I think, would be very useful, because that would really help many jurisdictions to frame their thinking about it and the way forward. Right, so I think that's really valuable, and that's very pragmatic, because indeed provision of textual basis for extraterritoriality is step one. We've talked a lot here about experience of BRICS, but in fact the initial experience of BRICS, because of the lack of textual basis, has not been so positive. They had to learn the hard way how to go about it, giving positive experience to other countries that followed later. So the experience, for example, in early 1990s has not been that great, right? And that applied to BRICS, but also applied to other jurisdictions. We had interesting cases in Chile where foreign cartelists challenged possibility of Chilean competition agency to apply domestic competition law, despite the fact that the same cartel has already been investigated in a number of other jurisdictions in the developed world. Right? So if you think about gaming of the system, yes, cartels are likely to do that. So I think that needs to be done. We need to also think about the entire chain of enforcement, and there are challenges which has already been touched upon and outlined in the report, such as dealing with, for example, rules of service. Right? How do you initiate proceedings? How to speed that up? Imelda talked very nicely about the Brazilian experience, and we have a number of very smart and elaborate jurisdictions which still struggles with such rules. And these are not only challenges faced by the developing world, these are still challenges faced by the developed world. We talked about access to evidence and more broadly information in such cases. And I think there is progress can be achieved in that regard. Some of that can, of course, happen within the collaborative framework, such as, for example, the cooperation between BRICS countries or more broadly within UNCTAD. But many of the things in that regard can be done unilaterally by interested developing countries, which could allow their competition agencies to seek evidence from partners and to provide assistance. That can be done and that could be facilitated. Of course, the big issue is recognition and enforcement of rendered decisions and judgments in such cases. We haven't achieved any progress here, even between the most sophisticated jurisdictions internationally. So, for example, between the US and EU. So there is still progress to be made. But more broadly, we still need investment of resources into trust building between agencies. And I think that's the space in which UNCTAD is doing a lot of good things, bringing people together, sharing know-how and sharing experience. And exactly sharing know-how and experience is very important, because quite often different countries are affected differently. And even if neighboring, they may have huge disparities of expertise in competition law. So being able to learn from one another is very important and useful. And even following what your neighbors are doing, I think, is very useful. And, for many listeners, this will be obvious, but language still becomes an issue, right? Because language changes between countries. Not everybody is fluent in English. Not all information is available. So I think I'll stop here, but there are many steps that can be taken, and the good news is that enforcement gap is narrowing down. So the situation for consumers is changing, and we've been talking about the trajectory over the last 20, 30 years. Teresa was talking about introduction of competition law internationally. So although formidable challenges remain, a lot has been achieved to date.
Thank you very much. I would like, just before we close, to ask still our other guest speakers if they want to add any final thoughts to these more or less closing remarks by Marek, because all of you raised very interesting issues. I think this conversation could be prolonged, but so Let me start with Qianlan again. Would you like to add anything? Would you like to comment on something? Would you have any suggestion of along the lines of these recommendations that could be considered at national, regional, or international level?
Thank you very much, Teresa. I think it's very timely that the report launched by UNCTAD and led by Marek is published. Given the application of competition law against business conduct outside of the territorial jurisdiction of a developing country's competition regime is somehow quite kind of a common practice now. And such a common practice actually set out the foundation for competition regimes, whether it's developed or developing economies, to set out the foundation for them to talk to each other, communicate with each other, and to a certain extent to collaborate with each other. What I find, so that's very promising. And I find that bilateral collaboration does motivate the competition authorities at various levels to understand and collaborate. But what I see that going forward, fundamentally, the current bilateral cooperation is based on the motivation to use the extraterritorial application of competition law to protect the domestic market from external harm. So that's the fundamental normative framework that's kind of shared by every competition regimes. It works because it helps everybody to talk to each other, but to a certain extent, it also can kind of generate certain challenges. For example, it explains why some regimes are less motivated to share, because the current investigation does not really involve that much domestic harm, or because the current regime has finished its investigation, it doesn't really require bilateral collaboration or support. So what is the main motivation to share the information? Marek, you want to... Going forward, the effects doctrine definitely is a set of norms that help people, attract regimes to come together because they have something to refer to. But somehow it might also be helpful to kind of review and reconsider the current framework and see whether there could be some innovative tools to somehow set out a minimum exchange of information and make the regimes more motivated to talk to each other, become more transparent towards each other. For example, in the area of agency-held information, for example, which are not really confidential information, but are held by agency. And somehow there could be a helpful framework that could make, for example, the regulation of international cartel more effective, but also more equitable. Thanks.
Thank you. Marek, you wanted to comment on something?
If I may jump in, I think that Qianlan raised a very important point, and I'm not sure whether all listeners would know, but she has an amazing paper forthcoming in World Competition, which I can highly recommend. Qianlan raised the issue of what would be the interest of some competition agencies of sharing information and perhaps even evidence. And I love this question because it's a very pertinent one. It's an important one which need to resolve. I like to think that actually sharing of information and even evidence with others empowers your own domestic regime, because you not only penalize violators who harmed your consumers and perhaps businesses in your jurisdiction, but it's also sending a strong message. If you harm in this jurisdiction, we not only chase after you, but will help others to go after you, right? So if you think about it, there's positive externality. There is a capacity to empower not only your own competition agency, but also a capacity of empowering others at pretty much zero cost. So I like to think about it quite positively. Thank you.
Let me just say that I absolutely agree, even though I don't think it is a clear-cut case, just to also share with our listeners that UNCTAD adopted in October 2020 a document entitled Guiding Policies and Procedures under Section F of the UN Set on Competition. Section F is devoted to international measures and, of course, among other things, strongly advocates for cooperation between competition authorities. And after 2 years discussions, after a very interesting proposal brought by the Federal Anti-Monopoly Service of the Russian Federation, we were able to agree internationally on a number of practical steps and some guidelines that could be of assistance, especially to the young and small competition authorities of developing countries. And we have had so far received 2 requests because, among other things, this GPP document provided for an increased role of the UNCTAD Secretariat as a broker, between brackets, as a mediator. And I think that was very appropriate because this is what international, especially intergovernmental organizations are all about. And I wanted to tell you that even though, of course, we have faced legitimate obstacles, let's put it like that, due to the different legal systems, to the lack of committee provisions or bilateral cooperation agreements, we've had a very recent, interesting, positive experience that related very much to what Imelda mentioned. So the sharing of information that was not confidential by a developed country competition authority, but that was extremely helpful and really committed to assist a developing country's competition authority. So that also encourages us as the UNCTAD Secretariat, so that there is still room to improve. And this goes back to the importance of trust and of bringing competition experts together and exchanging information and knowledge. But I would like to hand over to Imelda to hear any final thoughts or any comments on what Marek and Qianlan have just said.
Thanks, everybody. One thought I had that we might not have mentioned in relation to the sharing of information, which is the role of criminal sanction and then constraints that are imposed on agencies should they wish to share. That's not the purpose of this discussion, but I think it's important to flag it as a relevant and correct constraint on sharing that we need to factor in. And again, the Australia-New Zealand committee arrangement is useful in that respect as a model. But I don't know how one fully squares that circle. On the one hand, having criminal sanctions, because that can be very powerful, but on the other hand, it really can constrain the extent to which information can be shared. I'm very heartened to hear of the experience of UNCTAD as broker. I think that's a very important role, because I feel for some agencies, while I agree with Marek that it can be low cost to share information, I think sometimes agencies have to account for what they do so carefully that they can be limited as the extent to which they're allowed to cooperate. They're allowed to expend resources that have an impact outside the jurisdiction. I don't mean to be so negative, but I'm very pleased to hear the positive story coming from UNCTAD. Thanks.
No, thank you very much. No, I think it's quite an interesting experience, especially, of course, maybe this is your case also, but I've done most of my career actually in competition law enforcement. So of course, I think it's very helpful that one can really relate to the constraints, to the reservations, as you said. So it's not just a question of the legal framework and requirements, but I think it's also a question of attitudes. And frankly, let me say that UNCTAD, for that matter, compared to other international organizations, has that advantage because we are intergovernmental. That means that our 195 members are equally entitled to ask for our assistance, to our intervention, to our support. And that sort of legitimates really our best efforts in reaching out to others, to more experienced competition authorities in this case, to support. And frankly, I would have a very positive assessment. And on this note, let's hear again from Alexey. So any let's say final for the time being suggestions on how we could proceed? You already mentioned interesting references. I do see a lot of potential, and this is again what we at UNCTAD believe on this regional, not formally, but this regional type of cooperation of community, as you mentioned. But what would you like to add? Over to you.
First, I want to congratulate UNCTAD with the real significant progress for last 2 years. We see it on this topic, and that we really like building some sort of framework on international cooperation in competition sphere. it gives hope that one day we can come closer to international regime for protection of competition on global markets. Because I'm a bit kind of maybe fixated on this, but we do see the unequal, situation, unequal relations between authorities and global corporations. So global corporations have, dramatically better access to information on all, aspects of functioning of the market, dramatically more resources. So it's really like imbalanced. So there is no level playing field. So leveling this playing field, that's a very big deal, I think, for except maybe American and American authorities and European Commission. Even like China now doesn't stand in this line. So we still have to formulate somehow how to make authorities more equipped, more capable in dealing with dramatic changes what we see in global economy. That's I think an essential thing, and it's great that UNCTAD is moving into this direction. I don't think I want to a little bit comment on what was previously said. I don't think that authorities have to care so much about secrecy, to be honest, because companies don't care much about keeping public data, in the way they should be kept. We hear, I mean, we know that they abuse their control of big data in enormously, like in all possible instances. I think we are too much fixated or kind of stuck in this industrial age, concept of confidential information of industrial nature. I don't think in other areas of social importance, let's say healthcare or I don't know, financial monitoring, where we deal with some criminal activities like money laundering, authorities are that, cautious not to disclose something which has, a label of secret. I don't think that's, if you compare values, on one side we see enormous concentration of market power everywhere, huge abusive, practices of abusive nature, they broadening, more and more different forms of abusive behavior we see against consumers, and authorities kind of incapable to grasp with this, growing massive avalanche of problems. And on the other side, it's one value is to protect consumers, people, businesses against this type of monopolization processes. And on the other hand, we say like value of commercial information, of confidential information, that would discourage companies to cooperate. I don't think those are comparable values, to be honest. I think we are a little bit too much fixated on this parameter of secrecy, and we should be more on sharing side rather than keeping it protected. That's what my take. Kind of, I don't say that open up everything, should be like open access to all the data, but I think in principle the trend is a bit wrong. I mean, not trend, but the status quo. So we have to establish a different trend, set another trend. So setting tendency should be like more sharing, more access, more kind of collaborative usage of data. And here I see a lot of progress already going on. And one of the initiative which was discussed in the BRICS framework, and I do hope that probably it will be somehow implemented in near future. But the idea was very simple, to prevent some sort of strategic behavior, forum shopping, maneuvering by global corporations when they apply to the authorities for clearance of their mergers. Because what they're doing, they strategically apply, to one authority first, then they wait until procedural, terms end, and then they go to other authorities and so on. Put in our laws, in national laws. We don't need even international treaty on this. Just mention within procedural codes of different types that if you apply or have to apply in the future to other authorities within BRICS community, let's say, or it could be a broader community, it could be like BRICS plus community, it could be any type of community, you have to disclose same set of information to each of the authorities. It doesn't matter whether this information covers all the particular, problems this authority deals with in the national economy. It's important that all authorities are informed equally, so they can, rely on the same type of data to make their, decision. And I agree what was said initially, the Qianlan and Marek, that that could be some, a lack of incentives by the authorities to do this. But if you put it in the law as a principle, there will not be discussion, no kind of discretion. If you put it as a principle within national laws, saying like it's just fair to share information, it's like fair to discuss a case in the court when you do like discovery. First you open up all the evidence you have, and then you make conclusion. You have to open up what kind of data you have when you're making a merger, when you kind of concluding a merger. You have your business judgment based on some sort of data. Share this data, open up, and let authorities decide on a informed basis. Because now it's like a discussion between blind and deaf. Sorry, when one knows what he's doing, others don't know what's actually his or her intentions in this particular case. It's very kind of confusing. So what I'm saying, international cooperation is essential in building, more kind of informed and capable decision making on the side of authorities everywhere. And I'm sure that as soon as you start this type of process of sharing, developed countries will jump in immediately, because they also suffering from the same type of problems, same type of all national, I think, authorities in Europe, they would be happy to get more data on behavior of Google or I don't know, pharmaceutical companies like Pfizer. They want to know what these guys actually doing, thinking when they, either starting, their mergers and acquisitions or change their business models. What actually behind this? What are real intentions? And this type of things are, I think, a future of antitrust law in the world. And I hope that UNCTAD would be on the frontier of this movement. That's my kind of take on this.
Well, thank you. That is a very encouraging final remark. Thank you, Alexey. I don't know if our other guest speakers would like to comment, because if not, I would like to close this podcast, handing over to Marek, since it was his report that allowed us to meet and to have this interesting conversation.
Thank you so much, Teresa. There's no doubt much research is to follow, but I don't want to abuse your time. Thank you so much to all of you for joining us. Many thanks to Teresa and UNCTAD for facilitating this work, and indeed for sharing today, and to all our discussants for joining us today and expressing their views. And I hope this was an interesting episode of our LawPod podcast. To all the listeners,